The issue today was somewhat of a technical one, but very important to the courts. There's a statute that says that if you're challenging most taxes, you first have to pay the tax, ask for a refund, wait 6 months, and then, and only then, can you challenge most taxes. And the question was whether the penalty that is collected by the IRS should be treated like one of those taxes. If that's the case, then this suit, or at least the challenge to the individual mandate, would have to wait until at least late 2015. None of the justices who spoke today, and 8 of them raised questions, seemed willing to wait 4 or 5 years. I think that all of us in the courtroom today should have come out with a similar conclusion that the justices are not going to find that the Anti-Injunction Act bars consideration of the individual mandate claims. And the only question is, on what ground will the justices decide that the Anti-Injunction Act doesn't apply? For those of us who really care about the challenge to the Obamacare statute itself, or who especially care about the constitutional issues at stake, what's really important is that this Anti-Injunction Act is not a bar. We can get to day 2, we can get to day 3, and the justices will decide at least some of those more important issues. The preview for tomorrow is, let's say, the big event. The big event is whether it is constitutional for Congress to require all individuals to purchase or obtain health insurance. And there was a little bit of a hint in today's argument about that, because one of the contradictions in the United States government's cases, they say that the mandate and the penalty is not a tax under the Anti-Injunction Act, but it is a tax under the Constitution. And one of the justices today asked the Solicitor General if that wasn't a contradiction in terms. And the Solicitor General, without any fluster, maintained his position, which some people might think is a little bit too thin.